It's Robert. Hi. Yes, Yeah, I see him. I got him. Thank you. Janeiro. Morning. If you can unmute. It's a blue button on your screen.
Thank you.
Okay.
I'm unmuted, I believe. Can you hear me?
Yes, Mr. Torres, how are you doing?
Good. How are you, Judge?
Who do we have on the screen? Well, now the screen went away. Joel Lopez.
Your Honor, Mr. Lopez is one of Mr. Sanchez's employees.
Okay. Can he unmute and put his video back? Oh, now we have, there we go. Okay.
Both of those gentlemen, Joel and Jimmy, are employees of Mr. Sanchez.
Okay. Okay, can I have anybody that's going to offer testimony? Please raise your right hand. You swear the testimony you're about to give should be the truth, whole truth, and nothing but the truth. So help you God.
Yes, sir.
I do.
Okay, Mr. Torres, you had we have a defendant's second motion for continuance. Is that something you want to advocate for?
Yes, Your Honor, absolutely. And I noticed when I logged on that my client, Eric Sanchez, was on the screen. I don't see him anymore, Judge. And I don't know what happened. But
I don't see him here either. I don't.
yeah, he had joined and I don't know what
Hey,
happened.
he's trying to unmute.
I'm sorry.
He's trying to hook it up. He's on mute. Let's go.
He's on mute. Is that what you're saying?
Yes, he's trying to hook the. He's in mute.
Okay.
What?
So he's there with you?
He's on the other room.
Okay. Okay. Well, we'll wait a few minutes to see him get on.
I think he probably lost the internet or connectivity, Judge, because if he was on mute, we'd see him, or at least his name, and he was on the screen when I logged in.
He logged him out. Is what happened. He's logging back in.
There's somebody. This is Mr. Sanchez, you said?
Yes, Your Honor, that's the owner of the respondent company, Eric Sanchez.
Sanchez, if you can unmute, you press the blue button on your screen. You got to unmute. I can't hear you. It's a blue button. It has a microphone icon. It's on your screen, the screen that shows your picture. It's a microphone icon. You unmute, blue button. Mr. Sanchez, can you hear me? I can see that you're talking a lot, but I can't hear anything you're saying.
Lost him.
We're trying to get it connected. His microphone's not giving him access at this time.
Okay, he needs to unmute. He hasn't pressed the unmute button for one. That could be the problem.
We tried it, but it says unable to access the microphone. Let me try to get his microphone access.
Okay. Okay, Mr. Torres, do you need him for to argue your motion for continuance?
No, Your Honor, I don't believe so.
Okay, go ahead.
Yes, Judge. I filed this motion late in the afternoon, and I apologize to the court and the parties for that, but I didn't see Ms. McDermott's emails. There was a series of 8 emails. 7 of them contain attachments, numerous attachments. I had been mediating a child welfare case, a termination child welfare case, and I didn't get off the computer. We didn't end that till 2 o'clock. And then I took a break, came back and checked my email, and I saw Ms. McDermott's emails, and I started looking at them, and I started trying to figure out what they were, and I scanned through them, and then I realized that I had no option but to file the motion for continuance. There are a substantial number of attachments to each email, and I'll get into that, into the attachment issue in a minute. But in reviewing and scanning through them, and I just realized, Judge, I had no idea these were going to be presented. I'm assuming, and I cannot speak for the plaintiff, but I'm assuming that there would be offered into evidence. So I didn't know and understand the contact. I called my client, and most of these, Judge, are text messages.
Yeah, which your client would have.
Excuse me?
Which your client would have.
Your Honor, can you hear me?
Yes, I can hear you.
Okay, sorry, I switched computers. I don't know what's going on. My other one, it would not allow me to access
Okay.
my microphone.
Okay, Mr. Torres, go ahead. I'm sorry, go ahead.
Right, and responding to the court's statement that my client should have, but I don't know that, and there's so many of them that contain statements and photographs and questions that I need time to review them with my client to determine whether he has them and whether there were any responses. And I understand, the plaintiffs are not attorneys. There's a different relaxation of the rules of procedure and evidence in JP court, but it's still a basic tenet of fair play and the ability to prepare for this trial. Some of the emails have numerous attachments. Some of those attachments set out in that they are multiple pages. In clicking some of those emails or some of those attachments, I only find one copy of the phone screen. I don't find, for example, there is a an email that was sent at 2:04 p.m. yesterday, and one of the attachments designates that it is an 8-page attachment. I clicked on that. I only find one page. So my question is, did I not receive the other 7 pages? Is it only a 1 page? So there's some questions that need to be answered in order for me to understand what these exhibits are. And number 2, these exhibits are not numbered. So I don't have any idea how, in what order they would be presented. You know, the bottom line, Judge, is that these, like I said, most of these are text messages that my client may or may not have received, may or may not have. And so I don't anticipate that I would have any objection to the admission of these text messages if the plaintiff so desired to offer. But I need some handle on what they are, review with my client and review with some of his employees, because some of these text messages are directed at an employee. And I need to meet with them. So I'm asking for a short reset. I'm asking for 2 weeks to give me a chance to review these things and then come back to court. Because at this point, it's a surprise. I'm dealing with potential evidence that the court may be asked to admit, and I have no idea of what they are, and I haven't discussed them with my client. It's just fundamental fairness, Judge.
I assume you're not presenting any evidence?
Other than the testimony, Judge.
No, you're presenting no documentary evidence?
No, I mean, I think that the plaintiff has presented some, but the only thing that
what I'm asking is in these Zoom hearings, you're to get the exhibits to the court beforehand so that we can, everybody can see it. That's why we're requesting them. And
Yeah.
you haven't submitted anything, so I assume that
I have it.
Okay, so you don't have any documentary evidence.
Not that I intend to offer, Judge. It would be all testimony from my client, Mr. Sanchez, or his employees.
Okay. From the McDermott's, any response to Mr. Torres's argument?
Yes, Your Honor. Let me ask my wife to respond, because she's the one who sent everything, and
Okay.
she's the one who high tech exclusively.
Your Honor, I apologize. Initially, when this hearing was set, I had sent all these documents on March 31st. And in preparing yesterday, I had realized that only one of the documents in an email was sent. So all these others that Mr. Torres is speaking of did not get sent to your email. And so yesterday I called kind of frantic because I was preparing. I said, oh my gosh, none of this got sent. I had kind of stopped after we had canceled the other hearing. And so when I got back to it, that's when I realized that none of this got sent, and I did not want to not have it sent there and presented. So my apologies to that I did not realize it sooner, that these documents, they are mostly text and some other documents that were sent, but again, for whatever reason, did not get received. So yesterday, I just sent them one at a time. I sent them to Mr. Torres's office, 3 documents at a time. So,
Okay, I guess my issue with it, we've already had one continuance in this case, and the documents are to send to the court. It's not in response to any discovery. Mr. Torres, you could have done discovery, but these are just documents so that we can get them here to the court and present them to everybody. I mean, if they're all just text, they're to your client has them. I don't see, this is going to be no surprise to him if they're texted he's received.
But
So-
Judge, Judge, it is a surprise to me. And Ms. McDermott is correct. I received the email yesterday. She gave an explanation. I understand that. I'm not griping about that. I'm just saying, well, she may have them and had reviewed them and sent them or received them, and the employer, Mr. Sanchez, I haven't had a chance to look at them, an adequate time to
Did you
prepare.
do any discovery?
Well, I didn't, Judge, because I didn't think I was going to get exhibits the night before or the afternoon before. I mean, you know,
When did you think you'd get them?
I didn't think I was going to get anything because we were the day before, and I just didn't think that the plaintiffs were going to offer anything. I mean, you know, and I didn't send any discovery to them because I know they're not represented by counsel. I know they're not familiar with you know, the legalities. So I just thought we were going to have a hearing. But then when Ms. McDermott sent all these exhibits yesterday, Judge, it's just fundamental fairness to have a few, you know,
I'm
some
gonna
time
go-
to prepare. That's all I'm asking for is, you know, 2 weeks, 10 days, something like that, to get a chance to review them and review them with my client and his witnesses.
I'll ask McDermott, do you have any objection to it being continued?
No, I have no objection.
No, there are texts, like I said, there are text messages. They do have them, so.
Okay, if there's no objection, I will reschedule it. Let's get on that. Ben, can we get a date as soon as possible?
Sure. Let me see what I've got here.
It's just a matter of.
Your Honor, may I make a suggestion to Mr. and Mrs. McDermott about the exhibits?
We would have figured it out real quick.
And I would ask that whatever exhibit they're going to offer into evidence, that it be numbered so that when they offer it, we can refer to it by number, and I can look it up by number and follow it that way, so it can be properly designated and properly admitted and identified. It's just a suggestion. I mean,
I don't have a problem. I, you know, like I said, they are text messages that, you know, but I will be happy to send them to you numbered because I did number my particulars, so.
right. And the other thing, Ms. McDermott, I received a number of copies of the same exhibit, and I don't know if you needed, you know, the same text message for a different purpose, but there's some redundancy, and so.
It was by accident. I'm sorry. I did notice that. I was trying to send them 3 at a time because
Right.
I think that happened initially when I sent it, that I sent it in a bulk email. And so it was probably too much to send in a file. And so it gets received. One of them did, but the others did not. So then when I started to send them to you, then I realized that it was sending
Right.
what I had really sent. So my apologies to that.
No, that's not a problem. It just makes it simpler for us, for the court, to follow the exhibits if they're redundant and you didn't have a reason to copy them twice.
Your Honor, would you like for me to just resend them to each one of us? And that way everybody has them properly?
Whatever you send, if you renumber them, whatever you send the same thing to the court. That'll be fine. That way we're all looking at the same thing.
Right.
Okay.
Okay, Judge, so I have June 1st at 1 p.m., June 8th at 12 noon.
Okay, the party's June 1st at, I'm sorry, what'd you say, Ben?
Okay, so I have June 1st of 2021, I'm sorry, at 1 p.m.
Does that work for everybody?
Judge,
That
that works for me. That's exactly 2 weeks, and that's what I'm asking for.
Yes, sir. Yes, Your Honor.
Okay, so June 1st at 1 p.m.
Yes, Your Honor.
And it'll be the same Zoom information. I'm just going to reschedule it.
Okay, thank you, Mr. Garza.
You're
Thank
welcome.
Anything else that we need to discuss or clear up?
Not for me, Judge.
My apologies.
No,
I'm
no
very
problem.
sorry.
No problem. Thank you all, and we'll see you back on June 1st at 1 p.m.
Thank you,
Thanks,
sir.
Bye-bye.
Your Honor.